Hi, I'm Louisa Sijabat, a liquidator and bankruptcy trustee. So today's question is, if I'm a solicitor and the person who's come to see me may be about to declare bankruptcy, how do I prevent my legal fees becoming subject to something like an unfair preference payment clawback in that person's likely bankruptcy? This is a really good question. In order to answer it, I first should explain what an unfair preference payment clawback is in someone's bankruptcy. The concept of unfair preference payments is that if the person has had some money and paid down some creditors and not others just before their bankruptcy, that money should be brought back into the pool of funds and redistributed evenly amongst creditors. For example, just say the bankrupt owes his brother some money. The soon-to-be bankrupt owes his brother some money. Just before bankruptcy, he might use all his available funds to pay down the debt he owes to his brother, but not pay, say, his trade suppliers, the tax office, or other creditors. The concept in bankruptcy is that that amount should be recovered from his brother, even though the brother may be owed a valid debt, but that the funds should be recovered and spread more evenly through that person's creditors. Now, this also applies if the person or company receiving those funds before that person's bankruptcy isn't related to the bankrupt or soon-to-be bankrupt. So more formally, an unfair preference payment is when a payment or some sort of transfer of money or assets goes to a creditor that gives them some sort of preference or priority over the other creditors if that payment or transfer of assets or money or something like that happens roughly in the 6 months before that person's bankruptcy, although sometimes that period can be a little bit longer. And then what happens is that person's bankruptcy trustee may go to the person or company or organisation that's received that payment, even when they do have a valid debt, and recover that money into the bankrupt estate. It's a little bit of a hard concept to process, because what you've got is somebody who's genuinely owed money usually, having to repay the money they were genuinely owed and genuinely receiving to the bankrupt estate. Now, given that this concept does exist, lawyers who are then advising someone who's potentially about to go bankrupt, who tend to be quite aware of this concept, are like, what should I do? Because I don't want to end up with, say, unpaid legal fees, receive payment of them, and then have to give that payment to that person's likely bankruptcy trustee. So, the concept of an unfair preference payment, one of the key parts to the concept is that it's centered around payments that the soon-to-be bankrupt makes to a creditor in respect of a debt. Now, if there's no creditor and there's no debt, then it can't meet the definition of an unfair preference payment, and so it can't be clawed back. So what we're talking about here is things like prepayments. So if the bankrupt, or soon-to-be bankrupt, were to prepay before the lawyer is the creditor or before there is a debt, then that won't meet the definition of a preference payment clawback in the event of that person going bankrupt at a later date, especially if it's within 6 months of when the transaction's happening. So if you've got any questions around this, please feel free to call. It is a bit of a funny concept conceptually. There are reasons for it, and there are things that people can do to protect themselves from becoming subject to one of these clawbacks in someone's subsequent bankruptcy.